We have the court on the line. This is a time set for matters in the case of iCap Enterprises, Inc., case number 23-01243. The matters before the court today is a status conference and omnibus hearing. We have a motion identified in the case docket as ECF 370, motion for order establishing procedures for sale of property of the estate, and two other motions, ECF 550 and 553, which are motion to authorize debtors to terminate consulting agreement with Chris Christensen, and a motion to shorten time. On the line on behalf of the debtors, we have Dakota Pierce.
Good morning, Your Honor.
Patrick Jones.
Good morning, Your Honor.
Julian Garuli.
Good morning, Your Honor.
And Khaled Tarazi.
Good morning, Your Honor.
On behalf of the Creditors Committee, we have Jay Kornfeld.
Good morning, Your Honor.
Amy Willard.
Good morning, Your Honor.
And the Special Counsel, John Bender.
Good morning, Your Honor.
Assistant U.S. Trustee Gary Dyer.
Good morning, Your Honor.
On behalf of Serene Investment Management, LLC, we have Vadim Rubenstein.
Good morning, Your Honor.
And Michael Feinberg.
Good morning, Your Honor.
Darren Kratley on behalf of Redmond Funding Group.
Good morning, Your Honor.
Matthew Lesnick on behalf of Christopher Christensen.
Good morning, Your Honor.
The Paladin Management Group, the CRO of iCap, we have Lance Miller.
Good morning, Your Honor.
Garrett Ledgerwood on behalf of Socotra REIT, We Alliance, and Jason Yelowitz.
Good morning, Your Honor.
Jesse Baker on behalf of Wilmington Savings Fund Society.
Good morning, Your Honor.
And Jason Ayers on behalf of Umpqua Bank.
Good morning, Your Honor.
And I apologize, I missed one person, Ryan Free on behalf of Jim Christensen.
Good morning, Your Honor.
Is there anyone else on this call that I did not identify? This hearing is being recorded. Please proceed.
Right. Good morning, everyone. I hope you're all doing well. Sort of a few things before the court. I think it makes sense to first cover the sale procedures motion in the revised order that I saw was filed yesterday. Once that's done, counsel for Redmond and Wilmington Savings can drop off if they like or stay on for the rest of the hearing. Then I'd like to cover the termination motion, the debtor's motion to terminate the consulting agreement. Then I think we should talk a little bit about where we're at with the Ponzi issues. I saw Mr. Dyer's papers yesterday. I've been thinking about this some more a little bit, and I saw the debtors yesterday sent out a new notice. We should talk a little bit about how the game plan in connection with that. There's also the laptop adversary proceeding. I think we'll be talking about that further in connection with the termination motion. Before we get into weeds on any of those three things, Mr. Garuli, I read the debtor status report. I don't know if there's anything high level you'd like to add about the status of the case before we start it. Maybe that most of what's going on is going to come up in the course of covering those three categories of items this morning.
Yes, thank you, Your Honor. For the record, Julian Garuli of O'Melveny for the debtors. Your Honor, I think that does make sense. I think we obviously have some relief requests before the court today, and Your Honor, in my outline, I was also hoping that we could use some of your time, Your Honor, also because we are obviously game planning for the hearing on March 27th as well, Your Honor. So I'll be a little bit in an MC role today. If we're taking sale procedures first, that will be Mr. Tarazi, who's been handling most of our sale issues, and Mr. Jones, who's on the line, will be handling consulting agreements and sort of looking toward scheduling. And I obviously am also on, if the court wants to engage in more detail on some of Mr. Dyer's issues from his brief, although I think it would be beneficial to chat about that a bit, Your Honor, but I do think ultimately they're further down the road issues. So thank you.
Okay. Thank you, Mr. Wood. All right. So why don't we jump into it? So, Mr. Trozzi, I've reviewed the notice with the revised redline orders. I followed the two-step process. I understand it looks like that resolves the concerns Mr. Dyer has. I was actually thinking maybe this could be done the other way, where the transaction notice gets docketed and then I'm pre-approving something to which there's no objection to the docketed process, but I'm fine and comfortable with this two-step process. I do want to hear from Mr. Baker and Mr. Cratley today, since it looks like that they're not entirely comfortable with the revised order and the provisions that pertain to them. I did have just one general question for you, Mr. Trozzi. So looking at the motion, I saw there was a grid listing, specifying the properties that are subject to the sale procedures. There are 5 properties listed. I was not able to track fully. I think people are describing the properties in a different way. So I wasn't sure if between Redmond Funding and Wilmington Savings, all 5 of the properties are subject to loans, secured loans from those 2 entities, or if there is another lender here. So if you can help me just track that a little better. And again, not saying anyone was doing anything incorrectly, but the descriptions of the properties didn't match up completely, so I wasn't able to figure out who has liens on what exactly.
Sure. Thank you, Your Honor. Cal Trozzi with Buckhalter on behalf of the debtors. Your Honor, on that specific issue, the properties that are included in the table are, I suppose, a little bit, they are grouped, but the Willow Street and the BH 112114 LLC, those are collateral of Wilmington. And by the way, Wilmington and Redmond obviously can correct me if I'm misspeaking here, but those are collateral of the Wilmington lender. And then BH Senior Care LLC, the Burien and Linwood locations, those are collateral of Redmond. I guess I will clarify that the Willow Street properties and the BH 1121 properties aren't quite 3 properties. As I understand it, it's closer to 9 or so, and it's just that the addresses are grouped there, but they are individual townhomes that could have their own PSA for individual sale.
Okay. But between the 5 that are listed, and there may be subcategories within them, the secured lenders on those 5 are either Wilmington or Redmond.
Yes, Your Honor, that's correct.
Okay, so the secured lenders who are going to be implicated kind of have already come out and are part of the party at this point. So that's mainly just what I wanted to make sure. So, okay, I got it. Thank you, Mr. Crosby. Mr. Cratley, why don't I hear from you first this morning?
Good morning, Your Honor. Darren Cratley here on behalf of Redmond Funding Group. Just as a brief introduction, Your Honor, Redmond Funding Group's an asset-based lender. They made a loan in November 2022 to BH Senior Care. It's one loan secured by 2 different properties. The loan was for about $1.65 million. The 2 properties are the Burien property and the Linwood property in that matrix. We filed a claim here about 4.5 months ago. There's been no objection filed to date, and as far as I can tell in the 2,400 pages of documents regarding the Ponzi scheme, there's no allegation that Redmond Funding had any involvement or knowledge of that Ponzi scheme. There's pending sales, at least as of the time we filed our response, of about $1.3 million for one property and $2 million for the second property in Linwood. Redmond's request is that those be paid at closing in the traditional form at closing on a real estate sale, since there's been no objection to those claims to date. The debtor's revised motion provides for moving those into a segregated account up to $2 million, and that would provide adequate protection for the bank. But it's merely saying that the lien attaches to that. There's no actual provision for a perfected lien in those deposit accounts, and that's one of Redmond Funding's concerns regarding the structure of this. To start with, the reason that we believe that this should be paid at closing, Your Honor, is that Redmond Funding's been an active participant in this. Bankruptcy filed a claim 4.5 months ago. We've objected to prior motions to include the prior motion that sought a potential priming lien against Redmond Funding. There's been no objections made. We've turned over essentially all the documents in an over-inclusive fashion in response to the 2004 motion that the court signed off on at the beginning of the year. Most importantly, though, in the latest pleadings regarding the Ponzi scheme, as I mentioned earlier, there's about 2,400 pages of documents outlining in detail the allegations of this Ponzi scheme. I could not find anywhere in there any sort of allegation that Redmond Funding either A, knew of it, or B, participated in it in any fashion that would justify avoidance of their liens. Also, along those lines, and this will be laying the groundwork, Your Honor, for our objection to pending motions regarding the Ponzi scheme, is we didn't see anything in there alleging that BH Senior Care was one of the entities that was receiving funds as part of the Ponzi scheme. Our reading of that motion is that there's approximately 40%, I believe, of the money used for the Ponzi scheme was generated from intercompany transfers. BH Senior Care was an entity that owned 2 pieces of real estate. Those pieces of real estate had tenants and were generating income. We don't know the exact details of that, but there doesn't seem to be an allegation that money was flowing into BH Senior Care in a way that would impact any sort of claim against our client. The debtors had time to address this, Your Honor. They've not flagged anything for the court as a reason for why the claim should not be paid at closing, and that's why we think that it should be paid in the traditional format at closing on this, unless the debtor can identify some reason between now and when that sale closes as to why that should not happen. If for any reason the court's unwilling to enter that order today, though, Your Honor, our alternative proposal would be, number one, is that we get a perfected security interest in that deposit account. I don't think that's a big ask. It's the equivalent of what they had in the land. Obviously, the client is uncomfortable with the perfected lien in real estate being converted into cash, being held by another party. Although I would hope that the bank and the other party would follow the court's order, there's not the same type of protections that we have with that as there are with a lien in real estate, unless there's control established of that account. So that way, the bank, the debtors council, everybody is potentially on the hook for the use of those funds. But more importantly, though, Your Honor, I think it's in the interest of both the estate and Redmond Funding Group that there be a deadline placed on how long the debtor wants to hold these funds. They've already had 4.5 months. They've already got all the documents that they would need from their 2004 request. It's time to make a decision on this, if there's a claim against us or not. We ask that they be given no more than 2 months to either object to the claim or file an adversary action to avoid the underlying lien, and if not, the funds should be released. These accounts are accruing interest of 24% a month. It's about $33,000 a month. If they're delaying on this for 3 months, that's $100,000 lost from the estate. There should be some pressure on them to avoid those unnecessary costs if there's not a reason to object to the claim. So once again, Your Honor, we'd ask that this be paid, but if for whatever reason the court's unwilling to accept, I would just ask that there be a deadline attached to this.
Thank you, Mr. Pratley. I understand how things would work outside of bankruptcy, but I guess, and I understand obviously you would rather have the money than have it sit in an account, but can you point me to something in the bankruptcy code that gives you a right to be paid at closing?
No, Your Honor. The only requirement is that it's mandatory that they provide adequate protection and that the trustees one with the burden to establish that. That's why we propose, I get the court might be concerned with this given the nature of what went on. We just don't want this thing to be left floating indefinitely. And if the court's not inclined to direct payment immediately, then our alternative as far as what should be a reasonable expectation for adequate protection is a perfected security interest in the deposit account, combined with a deadline for when the debtor is going to address this issue. Basically, if they're going to allege something, they might as well do it, Your Honor. And like I said, it's in the financial interest of the estate to make a decision on this sooner rather than later. And the debtor has not filed anything suggesting a reason that they can't make that decision. To the contrary, they filed pleadings stating that they've hired forensic experts. They've gone into an exhaustive determination of the scope of this Ponzi scheme, sufficient to file a motion to apply a burden of proof to every single party and interest in this case. Yet at the same time, they're showing up today, Your Honor, and saying, well, we just don't really know about Redmond Funding Group's loan. It's time for them to make a decision, Your Honor, and I've just asked that you place some sort of deadline on them to either pay us or file that action objecting to it.
On that, I mean, doesn't the economic reality put some pressure on the debtors? I mean, it seems like your client's very likely oversecured, so you'll get to add some interest. I'm not sure 24% is the right number, and I think the debtors would argue that's unreasonable under Section 506B, and maybe we have that fight if need be, but it's probably not going to be zero. Probably going to be higher than whatever interest that bank is paying on the segregated account, if anything. So there's a negative arbitrage the longer this sits unresolved. So, I mean, doesn't that economic effect put, and I'm sure the committee understands that and is going to tell the debtors, look, we don't want to have that negative carry go on forever. So doesn't that incentivize the debtors to get this wrapped up? Why do I need to
in theory, Your Honor, by
another deadline?
In theory, Your Honor, but I think everybody on this line has probably been part of a bankruptcy case where the things get delayed and pushed off and costs increase. I mean, we can see the fee requests in this case are already extreme. I don't see any reason why there should be vagary placed on that. I'm not saying that it needs to be tomorrow, Your Honor, but I don't see a justification for why there can't be some sort of a date in the future. Otherwise, I think this is going to linger. It's already lingered for 4.5 months, Your Honor. It wasn't a mystery that our secured claim was there. They had the information for that period of time. They've had every single communication regarding this loan. I'm not sure what further delay would provide for them. And the debtor's clearly pushing for expediency in a number of different fronts. I don't think it's unreasonable, Your Honor, to expect that same expediency on the part of the debtor when there's a known creditor, all the documents are available, the money is sitting there, and it's time to make a decision on what they're going to do on that claim. Once again, Your Honor, we're asking for this to be tomorrow. Whatever the court would be comfortable with as far as a period of time, we would propose 2 months should be sufficient, given that they already had discovery on this. And our client is an asset-based lender. They provided money to the debtor. There's no connection between these parties that would justify any sort of avoidance of the lien. If the debtor's going to do it, I think it would be appropriate for the court to apply some pressure on them to limit those ongoing costs. I mean, even if there's a fight over the rate of the interest, Your Honor, that's a cost for the estate. If we pay it off, that's not a fight that even needs to be had.
Okay, very good. Thanks, counsel. Mr. Baker.
Yes, good morning, Your Honor. My client is pretty much making the same arguments that my colleague there just made. So that the creditor counsel just made. So I don't necessarily, I guess, need to rehash that. We would join in those issues, the interest rate, the expense to the estate, and the time frame of just deciding whether they're going to pay these liens or fight them. The court did ask about specific rule that requires the debtors to pay our liens. I would just point out that under Section B, 363B, there's no specific rule, but it's sort of a matter of course in the sale that's under Section B. And under if they're proceeding under 363F, they need to at least raise the bona fide dispute. So at least we would know whether they're disputing our liens or not. So I don't know if the court has further questions for my client specifically. But otherwise, I would join in those arguments and raise those issues.
Just one, Mr. Baker. Your client also has a pending motion for relief from the automatic stay that I think pertains to some of these properties. That's not set for hearing today, but are you working with the debtor? And if the debtors are intending to sell and liquidate your collateral for you, is that going to resolve that motion for relief from stay, or is that potentially a coming attraction down the road?
No, we are working with debtors counsel on that, and if we were paid in full, that would resolve the motion for relief.
Okay, or if the debtors are liquidating the collateral in an amount sufficient to be paid in full and then escrowing it. I know you'd like the money right away, but that's probably a net a better result for your client than going to state court and starting a foreclosure process, right?
Absolutely. Yes, that is correct.
Okay. All right. Thank you, Mr. Baker. Mr. Tarazi.
Thank you, Your Honor. Khaled Tarazi again on behalf of the debtors. Your Honor, just starting with that last point on the motion for relief from Wilmington, I just want to make one item clear. Is one of the reasons why we are continuing to work with them as opposed to contesting that at this time is because that motion alleged that the debtors were not paying adequate protection payments, and we have been, and we provided them with that information, and that is why that motion is still pending, and the debtors haven't formally filed anything related to it. But that's more of a not necessarily an issue for today, but it is important to note, Your Honor, that the debtors have continued to pay adequate protection payments. And Mr. Cratley, as he suggested, needing additional or needing something or relief outside of what is required in the bankruptcy code, we just think it's inappropriate at this stage. I mean, Your Honor already noted that really all our burden is to ensure that these creditors' interests are adequately protected. And we have done so. We are proposing to segregate proceeds in an amount or in amounts in segregated accounts, separate accounts, amounts above what is required to pay their liens in full, and continuing to pay them adequate protection payments. The issue of a control agreement for perfected lien and a control agreement, that's outside of what is typical and necessary and ordinary in a Section 363 sale, where the order is specifically providing for attachment of the liens to the proceeds in the same extent, validity, and priority. So offering them something that they don't have, as of now, is actually in excess of what is required to adequately protect them, which is what we have already set forth in the proposed order. So I don't have a lot to add to that, Your Honor, other than to say that in terms of the timing here, the CRO has been very big on sequencing, and we have had today issues and we've had down-the-road issues this entire case. And yes, we have proofs of claim that have been on file for a few months, but as is clear from our recent filings, the debtors have been expending enormous resources toward a pre-petition investigation that is not specific to any particular lien avoidance. Those are down-the-road issues, and we will eventually get there, Your Honor. We're not looking to delay that phase of the case indefinitely, but it is not for today. And in the meantime, we're offering to adequately protect these creditors in line with what's in the proposed form of order. And so that's really my comments on those questions and those issues that Your Honor raised. I don't know if Your Honor, it sounded like you had conceptually no issues with our resolution with the United States Trustee's Office in terms of separating one order into a two-step process. So happy to answer any additional questions you have on that. But aside from those comments, I'll just take any questions Your Honor has.
Thank you, Mr. Crosby. So I don't think there's anything in the bankruptcy code that compels immediate payment at closing. On the other hand, in other cases, like in our Easter Day cases and other cases where there's been a sale of collateral where there's a potential dispute, sometimes the debtors make a business decision to pay, I'll call it the undisputed component of the debt to the lender just to avoid what usually, and I think here, will be a negative interest carry on that money. And then the remainder gets segregated and the parties can fight about that down the road. I'm just curious if at this point the debtors are comfortable paying anything to either Redmond or Wilmington at closing, or really things are so uncertain that the CRO's business judgment is that escrowing everything and continuing to have the risk of that negative arbitrage on even what may be undisputed principal balance is the best way to go under the circumstances.
It is the latter, Your Honor, and as Your Honor pointed out, we are not looking to delay this indefinitely. We're just looking to get to that phase of the case likely in the coming weeks, and we are very aware the pressure is on in terms of the negative interest carry, and the committee's aware of it too, and the committee supports what it is that we're doing here with this sale procedures motion. So, in our business judgment and the CRO's business judgment, those are down the road issues that we will take on efficiently, but just not today and not at the closing. And on that point, Your Honor, many of these properties are currently in contract, pending court approval and the following of these procedures, and many of them will close likely by the end of March or early into April. So we're not looking at, we're looking to get through this sale procedures motion promptly so that we can get to close on these properties, and then we can move toward other phases of the case, understanding that we have the pressure of the negative interest carry, and we need to get to the avoidance and challenge issues sooner rather than later, but certainly not today.
Okay. Thank you, Mr. Truzzi. Mr. Dyer, I jumped over you. I was assuming the two-step process that the debtors have come up here resolved your objection, but I would like to hear from you this morning if you'd like to comment on that or anything else relating to this motion.
Your Honor, you assume correctly. The revised order does take care of our objection. It's the matter in front of you for the findings that should be evident from the declaration that would come in with the order. So we're fine with the newly submitted version of the order. Thank you.
Thank you, Mr. Dyer. All right, so I'm prepared to grant the motion. Largely teed up and postured. The U.S. trustee's objection has been resolved, and I think the two-step process makes sense. The debtors are proposing to segregate amounts in excess of what are owed to both lenders. I think debtors can and often do pay at least undisputed components at closing to the lenders. Here, I understand the debtors are not prepared to do that, and I don't think there's any entitlement that the lender has in the bankruptcy code or otherwise to get paid immediate cash at closing. The debtors certainly are taking a risk that they may be incurring costs to the estate by not paying some of the debt at closing and by not expeditiously getting these issues resolved. We've referred to that as the negative interest carry, and I'll note to the extent that either the lenders are oversecured, they also get to add attorney's fees to the allowable amount of the secured claim, and at least in the Ninth Circuit, even if they're not fully secured, the attorney's fees, to the extent allowable under non-bankruptcy law, become part of the unsecured claim, deficiency claim. So there's an economic cost if this doesn't get resolved expeditiously. I think that I'm confident the debtors fully understand that, and the committee understands that. I'm not going to set a separate deadline because I feel like that would be kind of arbitrary. I don't have a rule or a statute to give me a deadline. I think the economic incentives here will motivate the debtors to move forward appropriately in terms of either teeing up claim objections or reaching settlements with both Wilmington and Redmond. Subsequently, though, Mr. Tucker, I would like you to add to both. So I have a couple nits I'll give you, but the substantive comment would be in the new paragraphs. I'm looking at the red line 5 and 6, the segregated proceeds paragraphs. I'd like you to add just another sentence to make crystal clear that the Wilmington and Redmond, respectively, will have automatically attached and being perfected liens on the funds in the account to the same extent that they had, and with the same priority that they had perfected liens on the property. That logically may be the result of other provisions of the order, but I think just stating that expressly here makes sense. Working with the depository bank for the segregated accounts to put a DACAs in place probably doesn't make sense, and I don't think it's necessary. It's common in financing orders for the bankruptcy court to provide that the replacement liens are automatically perfected pursuant to the order, and I'm happy doing that here. So maybe if you can work with Mr. Baker and Mr. Cratley to just add a sentence to those paragraphs, making that point explicit, I'd be comfortable with that construct, and I think it addresses that issue that was raised by Mr. Cratley. May I give you a couple other minor cleanup comments, Mr. Cratley?
Yes, Your Honor. Working off of the red line or the queen?
I'm off the red line that was filed yesterday.
Okay.
So page 7 of the red line, paragraph 3, little b, we've got the notice A, B, C, D, and then that F should be an E. Page 8 of the red line, so this is the newly added paragraph 3D. It's describing the declaration establishing 1, 2, and 3. There's some words missing, I think, in 3. So facts supporting a finding under Section 363M of the Village Code, I think, regarding or concerning any such property. Does that make sense?
Yes, Your Honor.
Okay. We talked about the segregated accounts. Paragraph 7 of the procedures order in the red line, I'd like you to delete. So I think this just tracks the old order. So pursuant to the rules, this order is effective immediately upon its entry, and then there's the clause that the debtor and the purchasers are authorized to close property. If you could just strike everything after the comma, so that last clause I don't think is accurate now under the two-step process.
Understood, yes, Your Honor.
Okay. Now, on the form sale order that will be attached to the procedures order, very minor nits. The first prefatory paragraph pursuant to the order, there's a missing closed quote on where we're defining sale procedures order. And then I think there's a missing space with the italicized declaration before the parent defining the Miller declaration. And then the final thing in that same order, this is on page 16 of the red line. It's paragraph O. I think, though, in the clean, that's probably a different paragraph number. I think it's tracking the prior one. But in the middle of paragraph O, there's a reference to Section 364 F 1 through 5. That should be 363.
Got it. Thank you, Your Honor.
Otherwise, with those changes, both the proposed procedures order and then the template sale order all look good, and I'm prepared to grant the motion and enter the order with those revisions.
Thank you, Your Honor.
Okay. All right, so let's pivot to the termination motion. And I think it may make sense for me to start just by chatting about how I'm thinking about this. So first, I guess, I think the statutory basis for what the debtors want to do here is Section 363B. I always get nervous, and I tell my consumer lawyers that if you come at me and your only authority for something you want to do is Section 105, you're probably going to lose. You can add Pepper versus Litton if you want to make it a little better, but if that's all you've got, you're still probably going to lose as well. I take a narrow view of Section 105 as an additional source of power, but Section 363B expressly deals with the use of property. Here, I approved the consulting agreement because the debtors are paying money to Mr. Christensen, paying money as a use of the money. The consulting agreement creates contract rights in favor of the estate. Contract rights are also property, so if the debtors want to stop paying money, that governs the use of that money, and if they want to attempt to terminate the agreement and cut off contract rights that the estate would have, that's a use of that property. So I think that where to ground what we're doing is Section 363B. It's not entirely clear to me that court approval for the release the debtors seek is necessary, but everyone obviously wants to avoid a footfall with this being non-ordinary course use of property under Section 363B, so I understand why the debtors are seeking it. I think the point Mr. Lesnick made about how we shouldn't be delineating the consequences of what the debtors propose to do is well taken. This isn't a rejection motion, but if it were, the Ninth Circuit had the decision Durkin versus Bender Corp. In Re GI Industries, Inc., 204 F3rd 1276, which is a Ninth Circuit case from 2000, that says that an assumption or rejection proceeding is really a summary proceeding. It involves only a cursory review of the trustee's business judgment, and it's not the time, barring from the Second Circuit's decision in Orion Pictures, it's not the time for prolonged discovery or a lengthy trial or really determinations of disputed factual issues. And that should be done in a separate plenary proceeding, either in an adversary proceeding or a more fulsome contested matter. That really, the bankruptcy court says, does this make sense to assume or reject? Either it does or it doesn't. We authorize assumption or rejection, and then whatever the consequences that follow from that are, they'll be fleshed out and mitigated later. And that's similar and also analogous to what we've done in this case already with the 5 leases on the Senza Kenmore property, where the debtor stipulated to the rejection, and in that case also to the termination, but everyone kind of reserved their rights on what flowed from that. So I'm also not sure an adversary proceeding is necessary. I think I'm prepared today, just applying the business judgment standard, to say that the debtor's position here is not frivolous or obviously wrong. So if the debtors, in the exercise of their business judgment, want to cease paying Mr. Christensen and send him a notice that they believe the contract's subject to termination, I think that would be a reasonable exercise of business judgment under the circumstances. I don't think I need or should decide today whether that's necessarily right on the merits or what the consequences would be. One way that this then could get procedurally teed up for that more detailed analysis and litigation would be that Mr. Christensen could come in and file a motion for an allowance of an administrative claim based on his view that the debtors are breaching the contract. The debtors could oppose that motion, and then we'd have an evidentiary hearing in the main case on that motion for allowance of an administrative claim, just like we might if I've seen, for example, in the press that the debtors in the Rite Aid bankruptcy case are just not paying their landlords, right? So they're breaching those contracts post-petition. That gets teed up substantively by the landlords coming in and demanding payment of an administrative expense claim, which is a contested matter in the main case. So that's subject to hearing from the parties. That's how I'm thinking about this. I have some thoughts, I guess I can share to the extent appropriate on the 3 subcategories of cause, although I do think there are probably contested factual issues on some of these on which we'd need an evidentiary hearing for me to fully resolve. But I've been talking a lot, so why don't I hear from Mr. Jones first?
Thank you, Your Honor. Patrick Jones for the debtors. I think, we obviously neither party cited the case you mentioned, so we'd have to look at that. But I think that the debtors are probably okay with that procedure. As we wrote in our reply brief, we also alternatively requested an interim order allowing debtors to continue to suspend payments, and this doesn't sound terribly different in practical effect from that. I don't know if Mr. Gruely had anything to add.
Thank you, Mr. Jones. I did see in the reply yesterday the reference to the interim order. That's kind of conceptual, I think, where I'm at. I'm not sure I'd call it an interim order because I don't know what phase 2 of this looks like, but what I'd be prepared to do today is enter an order to the extent a bankruptcy court order is necessary, authorizing the debtors to cease payment under the contract and just send a notice of termination to Mr. Christensen, but with all parties reserving their rights about the substance of that and the consequences of that, and then there may or may not at some point be a phase 2, and how that gets teed up kind of depends on what Mr. Christensen does and kind of how things unfold. But I'm not sure interim and final makes sense. It's really, I'm authorizing this just like I'd authorize assumption or rejection of a contract, and the phase 2 will come if and when it comes. So it's, I think, broadly similar to what the debtors were calling interim relief, although I wouldn't call it an interim order. So maybe we're just debating semantics at this point. But Ms. Gooley, if you'd like to add anything.
Thank you, Your Honor. For the record, Julian Garuli. Your Honor, I think that works for the debtors. Thank you.
Okay. Mr. Lesnick.
Thank you, Your Honor. Matthew Lesnick for Chris Christensen. I think that if all the court is planning to do is enter an order saying it's not improper for the debtor to stop making payments and send a termination letter without ruling on any of the underlying merits and without prejudice to either Mr. Christensen filing a motion for allowance of administrative expense or commencing an adversary proceeding for breach of contract, then I think that we're okay with that. I just, we do dispute that this was ever an emergency and it needed to be heard on a shortened time. We do, I'll be very brief about this. I don't want to get too far into it, but I do think that this is, there's a bit of an effort to try to steamroll Mr. Christensen, and, he's already under constraints with the money he's allowed to spend under the settlement agreement with the investors and the company. This cuts off his only current source of income, and he's facing, I think the state has about 9 professionals on the call today, and the idea that this had to be done on an emergency basis, for a relatively small amount of money, I would add, just seems to me more kind of a strong arm litigation tactic. But I'll get off that soapbox now, and if I understood the court's intentions correctly, as I said, we're fine with that.
Okay. Thank you, Mr. Lesnick. And you very subtly pointed out that I forgot to cover the pending motion of shortened time and kind of jumped right into it. So I think given the more limited relief that I'm prepared to enter today, I think shortening time on that makes sense, since we're not kind of getting into the meatier substantive issues. But I understand and appreciate the position that puts you and your client in since you first heard about this. I think we could go this past Sunday. Mr. Kornfeld, is there anything the committee would like to add on this?
Nothing to add, Your Honor. We appreciate the court considering it and your ruling.
Okay.
Your Honor, Matthew Lesnick again. I just would request that we be permitted to see the proposed form of order before it's submitted to the court.
Oh, yes, absolutely. Absolutely. And I'll comment just briefly on the 3 issues. Generally, I agree with Mr. Christensen that I don't think someone has an obligation to say, hey, I was running a Ponzi scheme. That's a disputed legal conclusion. And I wrote an opinion in a different case called Shoot the Moon, a Montana case, in a different context where, during settlement discussions, otherwise I don't think people have an obligation to incriminate themselves or confess to wrongdoing, particularly when they dispute that there was any wrongdoing. There may be an issue about whether predicate facts were shared or should have been shared. I think we're going to need an evidentiary hearing to drill down into that. Regarding the laptops, I guess there are multiple laptops, it looks like the parties are working to get this resolved. I certainly understand Mr. Christensen's position that, well, if I have email exchanges with Mr. Lesnick or other counsel that are on the laptop, or if there are drafts of motions or documents or anything else, that belongs to me and the debtors shouldn't have it. At least in California, and I think in Washington, there's an ethical obligation that if anything appears to be privileged, lawyers are not supposed to look at it and are supposed to immediately inform the other side and give it back. So the debtor should not have access to that material. I'm not sure interjecting me in the middle of the mechanics to operationalize this makes sense. I suspect someone somewhere at O'Melveny or Buckhalter has dealt with these issues in the past and has kind of the state-of-the-art protocol that on how to handle this and get this resolved. I think if there's a dispute about whether a given document or communication is privileged, that properly can come to me. But I really just candidly don't have anything to add in terms of like how we do this on the ground. It seems to me like both sides recognize there's an issue here in terms of the handoff and either getting confidential and privileged information off the laptop or ensuring that it's not somehow improperly provided to the debtors. So I don't, and that may moot and resolve the turnover adversary proceeding. I mean, based on the emails I've seen, it seems like the parties are working to make progress on this, and I have confidence that given the quality of counsel, you can get this over the goal line, and I'm not really sure what I can do to help on that front. Why don't I pause? Mr. Gurley, is there more guidance or anything I can do about this to help move it along? Again, I'm not in any way an expert on this, but I completely understand the issue, and I would think, again, someone somewhere at O'Melveny this is not the first time this has come up.
Yes, thank you, Your Honor. For the record, Julian Gurley for the debtors. Your Honor, I think those points are well taken, and I can tell you, Your Honor, that we have been speaking with Mr. Lesnick about these issues, and I don't think we have to or it's appropriate to get really into the details about those discussions right now. I do hear what you're saying. I think our main request, and I know you're raising this, Your Honor, in the context of sort of scheduling for the AP, would be to give the debtors and really the parties some definition around deadlines to get these resolved, because these are pressing issues. At the end of the day, we might disagree with Mr. Christensen about where the privilege applies and where it does not, and we want to sort of be able to efficiently sort of identify those issues, and if we have to bring it before Your Honor, do that. But I agree in terms of substance today, it's not the time to wait into it, but we would like expedited schedule to get that resolved, Your Honor. And I should say that we, as I mentioned, we have been meeting and conferring with Mr. Lesnick about it. I believe Mr. Jim Christensen has new counsel, and I don't believe we've spoken to them about this issue yet. Thank you, Your Honor.
Thank you, Mr. Glenn. I did see Mr. Free did file a notice of appearance in the adversary proceeding. We do have just the automatically scheduled status conference that the court presets on the docket for next month in the adversary. It might be longer than folks like, but Mr. Lesnick, do you have a sense of kind of where they're at and if this could be moved along reasonably timely? If counsel's cooperating on this, and from what I've seen, everyone is, maybe you can offline kind of come up with some deadlines. But why don't I hear from you, Mr. Lesnick?
Sure. Thank you, Your Honor. So I do think we can get this issue hopefully either resolved quickly or at least narrowed to the point where if there's a specific dispute, we can, present it to the court for resolution in an appropriate fashion. What we're planning on doing is just to let the court know a little bit about what's going on, not everything. But Mr. Christensen has delivered the computers, I think there's 3 of them, to one of his attorneys in Seattle, who's either holding the computers now or has already shipped them out to O'Melveny's Los Angeles office. If they haven't been shipped out, they should be shipped out imminently. With the understanding that nobody will review anything on the computers or access them until there's a stipulation or stipulated protective order and some sort of protocol to protect Mr. Christensen's privileged and confidential information. So I'm hopeful that the computers will be in the hands of debtors' counsel very, very soon, and that I'm hopeful that we could get a stipulation in place within the next week or so.
Okay, very good. Thank you, Mr. Lezik. Mr. Free, if you'd like to be heard.
Yes, Your Honor. I am new to the case, but I share the comments that I think this could be worked out in pretty short order because we would likely be comfortable with the same procedure.
Okay. Thank you, Mr. Free. All right, so I'm not going to set at this time additional deadlines relating to that adversary proceeding beyond what's been automatically set. I think counsel is continuing to discuss this and work in good faith, and I think everyone understands the issues and the importance of coming to a quick resolution. I think me imposing a deadline beyond that would be just a little arbitrary, but I would encourage continued discussions and best efforts to try and get this resolved, and if you can't, and there's something I can do to help, I'm certainly willing to do so next month. All right, the final issue, I guess, and I don't have a lot to say about this, and I'm obviously not deciding today whether this is cause to terminate the consulting agreement or not, but I'll just say it, and some of this I'm not sure is a bankruptcy court issue at all, whatever's going on with the new Sally Vault issue. I'll just kind of comment for what it's worth that maybe it's not a really good idea for Mr. Christensen to be doing this with his iCap debtor email. When I was in practice, we'd have people at our law firms who were doing things that were totally illegal or totally legal. No one was doing anything wrong. I mean, there were people buying and selling wine, buying concert tickets, doing all kinds of stuff, but they were using their firm emails when they probably should be using personal emails. So I'll just share that thought for whatever it's worth. Okay, so to sum up, I'm prepared to grant the debtor's motion to the extent court approval is necessary to cease making payments under the consulting agreement, and if they like send a notice purported termination of that agreement to Mr. Christensen, all parties' rights will be fully reserved and preserved in terms of the consequences of all of that, and it will be addressed by the court later to the extent teed up in a procedurally appropriate way. And I think it would be appropriate, Mr. Jones and Mr. Cooley, for you to share a proposed form of order with Mr. Lesnick and just make sure everyone's comfortable with the wording and on the same page. And if we need a further hearing about that, let us know and we can all hop on the phone. Okay. All right. So finally, let's talk a little bit about the Ponzi issues, and none of this is strictly before the court today, but I did read Mr. Dyer's submission. I did see the debtors filed a new, much more specific notice relating to their proposed Ponzi findings yesterday. I'm not sure exactly who that was sent to, but I think that addressed some of Mr. Dyer's concerns about notice. I've been thinking about this a little more, and I'll share some thoughts on both generally and then about what we're doing on the 27th. So generally, as I noted at our hearing last week, the court has not previously seen this issue teed up. I called it midstream, kind of the middle of the case. I've seen when I was in practice, was a person involved in a matter where a very similar issue was presented as part of the plan confirmation process. I don't think there's anything preventing me from resolving and making findings in the main case on a contested matter. If it works in the plan context, which I think it does, I don't have an analytically robust reason not to do that in a separate contested matter. I mean, there are important findings made all the time when bankruptcy courts approve sales or financings. under Section 364. One thing I'm hesitant about, and I may want some further guidance from the debtors about this, is it strikes me as odd for, assuming I make a Ponzi finding in the main case, for me to decide then what the preclusive effect of that finding may be on any particular litigation. I mean, normally, I think both in the bankruptcy context and the non-bankruptcy context, there's litigation one, which reaches a conclusion with a judgment or an order. And then sometime down the road, there's litigation number two involving particular parties, and one of the parties will say res judicata or collateral estoppel or Worker-Feldman or some other principle that prevents this issue from being relitigated in litigation number two. And whichever court has litigation number two will then decide in the context of that particular matter what preclusive effect the order that culminated from litigation one has. So in the bankruptcy context, an example of this that came to mind was the Chrysler Section 363 sale process, where Chrysler was sold in the main bankruptcy case with a free and clear order, and then later on, certain parties attempted to assert claims against the buyer, and the buyer argued those were truncated by the sale order, and there was a discussion about due process issues that eventually went up to the Second Circuit in terms of who was bound how by the sale order in the main case. Here, I think parties that have notice and an opportunity to participate or are actively participating likely will be bound later on, but there may be parties who know nothing about this, and if the debtors subsequently file an adversary proceeding against them down the road, I would decide it in the context of that adversary proceeding, but I think the court would be very likely inclined to say, well, no, of course you're not bound. You didn't know anything about this and had no opportunity to argue about it. So those are the two extremes. There may be parties in between where I'd need to decide this on a case-by-case basis down the road. And it may be that this issue doesn't get teed up. I mean, I'm a strong believer in the party presentation principle. If the estate down the road sues a particular party, argues, hey, Judge Holt made this finding in the main case, it applies here, and the litigant doesn't contest that, they've kind of waived the right to waive this argument. But I think it's procedurally odd and a little backwards for me to be deciding in what I've called litigation one who is or is not bound in down the road litigations 2, 3, 4, 5, 6, etc. I know, again, this isn't strictly before me, but Mr. Dyer raised this issue, and I've just been giving some thought to how that's unusual for me to say, again, who's bound in some speculative future litigation proceeding. That's not how that really works in other litigation contexts. So I don't know if that component of what the debtors are seeking is essential to what they're doing. It may be that my comments today kind of need to have some kind of further thinking offline in terms of defining today what the preclusive effects of a finding in the main case may be down the road in some other proceeding. Again, that just strikes me as highly unusual. I do think I am prepared to have this issue teed up and brought in front of me as a contested matter, and I think we're going to have a contested evidentiary hearing that likely is going to take more than a day. I'm a little worried about the time frame, and I'm also a little worried about the fact that sitting here on the phone today, I don't know who the parties are to the litigation. So the debtors have teed this issue up. They've sent out a notice. They've specified an objection deadline. I don't know who is going to be appearing and participating in the process. So it's a little hard to talk about what a trial looks like when I don't even know who's going to be involved in the trial because we don't know who's going to be objecting. I think I have some ideas that at least the Christensen's likely will be on the opposite side of the trial, but I don't know who else, if anyone, will be with them on this. So I'm inclined to just leave the schedule as is. The debtors have sent out notices and just sent out that new notice yesterday specifying the March 18th deadline. I'd like to see who objects and on what bases and what grounds. I think it makes sense to continue with the March 27th hearing in person as we've scheduled. But I'd really, at that point, I'm inclined to treat that as a preliminary pretrial conference where we can discuss next steps going forward based on who actually objects. Until I know who's objecting, I can't have an intelligent conversation with anyone about what they think is necessary in terms of framing issues for a trial. And I'm also not sure if we're having a fully disputed trial about this, if that gets done in one day. So I know this may not be exactly what the debtors were hoping for me, but I thought rather than hide the ball, it would be helpful to share my current thinking about this with you all. I will, though, Mr. Dyer, I know we've had disagreements about this in the past. I think what Chief Justice Roberts wrote in Bullard was a Chapter 13 case, but I don't think that statement was limited to Chapter 13. Logically, I don't think it makes sense to limit it to Chapter 13. Often the amounts of controversy in Chapter 13 cases are very small. Here the numbers are very large. I know I disagreed with the position the U.S. trustee took in the Easter Day cases, and part of my reason for disagreement with that was the fact that the longer the case goes without people putting money in their pocket, the worse everybody is. This is a case where I don't think anyone other than maybe the oversecured lenders will be getting post-petition interest or an extremely high interest rate environment. The prime rate of interest is 8.5%. Treasuries are between 4 and 5, depending on the day. So I think I believe what Chief Justice Roberts wrote in Bullard applies equally in this context for the same reason I thought it did in the Easter Day cases. But I appreciate if you disagree with that. I do, Mr. Dyer, agree with you that there is no expedition exception to due process. So I take the point on that. So, Mr. Gurley, I don't know if any of that's helpful or there's more you'd like to do on any of this today, but I think everyone needs to give some thought and maybe if there are authorities do some convincing to me about how in litigation one it makes sense to say who's precluded in subsequent litigations. And then I really would like to have a sense of who's objecting to the motion so that we can define what we're doing at the trial, and I just have no idea who that's going to be today. So, Mr. Gurley.
Yeah, thank you, Your Honor. Julian Gurley for the record. Your Honor, very helpful, as always, Your Honor. I think a couple of things in response. One is I hear Your Honor on sort of contested matter versus adversary proceeding. I think that sort of step one conclusion is absolutely correct and consistent with where we saw the authority on that issue. And obviously, Your Honor, for all of this, including whether it could be done in terms of a quantity determination as part of a contested matter was an issue that we spent a lot of time thinking about and consulting with, the creditors committee also on that point. And I think Your Honor is trending in the direction that we think is the correct one. I do hear your point, Your Honor, about litigation 1 and litigation 2 and 3 down the road. I think Your Honor made, this is off the top of my head, we'll absolutely take it back and address it in connection with a reply brief, Your Honor. But it does seem to me that you touched on something that probably is pretty important, which is who among the creditors that are creditors, parties in interest in this Chapter 11 main case with notice, which, Your Honor, even with the new notice that you filed last night, we noticed this out and filed it on the 23rd, the original financing motion in response to Your Honor probably put it together, Mr. Dyer's comment, which he was kind enough to share with us in advance of his opposition anyway. We decided without conceding that the first one needed supplementing. We thought, why not do another because we absolutely want this notice to be for the world. This is a critical step in this case. And so that sort of brings me to where I was headed, which is, I think, Your Honor, it seems to me, also thinking about it in terms of who are the parties that receive notice of this. Did they have an opportunity to come into this contested matter and object? Obviously, they have, discovery rights if they want to avail themselves of those in connection with a contested matter, just like an AP. And can we bind those parties in litigation one because they were, can we bind those parties in litigation two because they were, in effect, really parties in litigation one? And I do hear then, right, the further step, Your Honor, that if a party receives no notice of what we're doing on the 27th or later, and they would be bound, and that's a determination that would be better made by not be wrong, a different court. But I think, Your Honor, that's very helpful to hear your thoughts, and we'll go back, and I know we have time to address it, and we will. In terms of scheduling, Your Honor, I would emphasize this is a critical step in this case. I think it's obvious to everyone. It touches on a host of very interrelated issues in terms of what the debtors are trying to accomplish here. Not only, Ponzi determination itself and being able to unlock critically needed DIP financing to make sure that we remain administratively solvent and have a binding commitment from our DIP lenders to fund these cases. That's one reason, absolutely, Your Honor, that we would love to respectfully, I urge you to hold the 27th, and I can give you some additional thoughts on that too. But in the realm of intertwined issues, for example, the sale procedures and your comment in connection with Mr. Tarazi around, as long as sort of we don't know where we're headed here, can we really wrap up our lien investigation, for example, and we'll be kicking adequate protection payments as long as the main case is held up at this stage. Similarly, Your Honor, we're working with the committee to start thinking about what a plan of liquidation looks like, Your Honor, and the impact of the Ponzi determination is going to sort of, when that trial occurs, is going to push back sort of the timeline for clients. I know Your Honor's aware of that, but everything is really keyed off of this hearing. And so, Your Honor, what I'm happy, obviously, to do whatever suits the court. What Your Honor, I suggest is, could we set maybe a further status conference, in advance, like next week, or in 10 days in advance of 327, when we maybe fleshed out further who's going to be objecting, if anyone, in addition to Mr. Dyer, and what those objections look like. Aside from Mr. Dyer, Your Honor, I would tell you, we are anticipating some objections, but we have not received outreach, asking for, discovery depositions or things that would really necessitate moving 327. And I think if we just give it a little bit more time to see if that comes into better focus, we could at least hold open the potential to hold the 27th. And, Your Honor, if we need more than one day, the debtors are absolutely prepared to pick it up on the 28th or whenever pleases the court to. But I think that, as Your Honor said, is something that we're going to get more definition around. I would just really, Your Honor, sitting here on the 12th, I think we have a little bit more time to see if we could schedule the 27th. Thank you, Your Honor.
Thank you, Mr. Cooley. Ms. Kornfeld.
Thank you, Your Honor. Jay Kornfeld for the committee. I appreciate the opportunity to speak to the court for a minute. I want to emphasize a few things. The committee does join in this motion and very much is focused on the issue of speed, which has been discussed several times in this hearing. One of the issues for investors, and reminding the court we've got 1,800 of them, owed about $250 million, is that under the Internal Revenue Code, Section 165, as a result of the infamous Ponzi scheme Madoff, the legislature in our country changed the rules so that an investor that takes a loss for fraud purposes is entitled to do so under certain circumstances. One of the issues that looks pretty clear is that investors will have an opportunity to go talk to their tax advisors and potentially take that loss as soon as this court makes a finding, if indeed it does make a finding of a fraud or a Ponzi scheme. So that is one of the reasons why the committee is very supportive of speed in this case. The other is the reality that the ultimate findings are important both to litigation recoveries. We'd like to be pursuing those with the debtors more quickly rather than less quickly. It also moves us quickly through the plan process, and the committee is focused on moving through that process, getting a plan with the debtors and the committee collaborating before the court as soon as possible so that we can move to the other side of this process and be pursuing recoveries and finish the quote-unquote administrative part of this case. With those things in mind, the court's comments are appreciated. The one thing I would add about contested versus adversary proceedings, and I think at least for me, it comes out of the In re Bonham case out of the Ninth Circuit, 229 F. 3rd 750, which I'm guessing the court is probably familiar with, but that case was a bankruptcy in Alaska, and Judge Ross at the time entered substantial findings, some of the more detailed findings that I've ever read by a bankruptcy court, in a contested matter. And it was a substantive consolidation of debtor and non-debtor entities, and in the context of that ruling, Judge Ross also made a Ponzi finding. It went up to the Ninth Circuit and was confirmed and affirmed by the Ninth Circuit as being appropriate. And in large part, when you read that decision and related Ninth Circuit cases that follow it with respect to substantive consolidation and contested matters, what you find is really what this court has focused on this morning, which is the opportunity to be heard. The receipt of notice in a contested matter is actually considerably broader and more effective in a case like this for this type of a finding that is not particularized to any particular defendant, but really to the debtor, that the contested matter procedure offers a very broad notice to all of the parties that are involved in this case, and potentially more. Ultimately, we may be talking about who received notice at a later date, but the committee generally would look at it the way the court seems to be looking at it, which is a notice to be heard today and for the 27th, and for this court's ruling on the Ponzi findings is the key element of ultimately binding parties. All of that will come before the court at a later date, but generally wanted to share that view from the committee's perspective with a particular focus on the value of speed in this case, and that being one of the major reasons why the committee has been on board with the debtors and moving this before the court so quickly. Thank you, Your Honor.
Thank you, Mr. Kornfeld. Mr. Lesnick, I don't know if you want to comment at all about this. I'm assuming, and maybe it's a bad assumption just from statements in the papers, that your client's going to be opposing the motion and participating when we have an evidentiary hearing, and I think that when is not definitively decided in my mind. But you may just pass on saying anything about this today, which would be totally fine. But if you'd like to be heard, I'm happy to hear from you.
Thank you, Your Honor. Matt Lesnick for Chris Christensen. Just very briefly, Your Honor, I mean, obviously there's nothing on this motion in front of the court today, so I don't want to, I wasn't prepared to say too much about it. The only thing I will note, first of all, yes, the court is correct in assuming that Mr. Christensen intends to oppose the motion, and we will be filing those papers. The only thing I would say in response to a comment from Mr. Kornfeld is that while we understand why the committee and the debtors would like to do things quickly, this is going to be an extremely complicated and fact-intensive bit of litigation. We're, basically litigating, as somebody noted earlier, the motion contained about 2,400 pages of information. There's a ton of issues here. They're complicated. They're probably going to require extensive discovery. So I'm not going to, stand on ceremony about the difference between a contested matter and an adversary proceeding. All we're concerned about is having a full and fair opportunity to discover the facts that we need and make the arguments that we need. And that's all I have to say at this time, Your Honor. We'll put the rest of our position in our opposition papers.
Okay. Thank you, Ms. Lesnick, and I completely understand. Mr. Free, I don't know if you'll be participating or not, or if you'd like to say anything or not, but if so, I'd be happy to hear from you today.
Thank you. I mean, I do share some of the USD's concerns about due process, where this is a March 11th notice identifying the lawful pleadings for a March 18th objection. So I'll just sort of note those procedural concerns, but we'll add nothing more at this point.
Okay. Thank you. I don't know if I'm going to hear from Ms. Geyer, but before I do that, if there are other parties on the phone who anticipate opposing the motion who would like to be heard, and maybe folks are on and haven't decided or don't want to tip their hand, but if anyone else would like to comment, I'm happy to hear from you.
Your Honor, this is Darren Friendly for Redmond Funding Group. As we suggested during our earlier argument, we are planning on objecting to that motion. We have some procedural due process concerns. The more substantive issue for our objection, Your Honor, just to be full and open with everybody, is what we raised during our argument earlier, that it's unclear from the pleadings if any particular entity was a part of the Ponzi scheme, such to put the parties dealing with that entity on notice of the alleged Ponzi scheme. For example, in our case with BH Senior Care, that entity is generating revenue that would cover its expenses. Would parties dealing with that entity have any reason to know of the Ponzi scheme such that the presumption should apply to them? We're also struggling with the issue of we still can't figure out if the debtor is asserting a claim against us such that we need to defend it, which goes to the discovery issue of the cost-benefit analysis of how far down the line we need to go in ramping up for this, if we don't know if we are actually one of the parties that is a target for the use of that presumption. But as of right now, we feel like we probably need to do that, so we will be filing our objection on Monday, Your Honor.
Thank you, Mr. Cratler. Anyone else who would like to comment?
Your Honor, this is Jason Ayers on behalf of Umpqua Bank. I really echo the comments that were just made and the concerns raised by the U.S. trustee. We're in a situation where we don't know what claims may be asserted, what venue may even be pursued. To the extent there are claims, looking at the notice filed last night, it relates to parties that received transfers / payments from the debtors. Umpqua Bank had deposit accounts with the debtors. So, we're trying to wrap our head around whether, again, this presumption is applying to Umpqua Bank under these circumstances. And, again, the due process concerns. So at this point in time, we would anticipate objecting on that basis. But I certainly need to talk to some of the parties in this case to understand exactly what may or may not be asserted and how our client is involved at this stage.
Thank you, Mr. Ayers. Others who would like to be heard?
Good morning, Your Honor. Garrett Ledgerwood on behalf of Scotia Reed. I echo everything the prior counsel has said. We represent a lender on a piece of property, and it's not entirely clear to us whether our client is a target of these Ponzi scheme allegations. And so, it puts our client in a tough position where they haven't been named in a lawsuit, but they're looking to have to defend over 2,400 pages of information that the debtor has had multiple months together when they're not even sure that they're a target. So in addition to the due process concerns, we anticipate filing an objection also related to whether this is appropriate in the context of an appropriate finding in the context of a DIP order, and what are the limits to which a lender can request certain findings in connection with the DIP order. For example, could they request findings related to a product defect, because that's the potential litigation on which they're going to win. And so we anticipate having our objection filed before the deadline. We look forward to discussing more with the court on it. Thank you.
Thank you, Mr. Libby. Other counsel? Mr. Dyer.
Thank you, Your Honor. I think the court has understood the objection from us being filed early because of the scheduling that was done by ex parte motion. And I believe I hear that the court is actually not imposing the discovery deadline because the parties haven't framed up the issues yet. And I think that's the right course. Maybe I misheard the court, but I think that that's the right course because of the volume of information that's here. And I think that the last three comments sort of are emblematic of the not identifying the targets or the class of targets that will be subject to this. When you do a Ponzi forensic accounting, the money comes in from a source, is distributed out or through several entities, but is distributed out to an identifiable source. So in order to get to the Ponzi scheme findings, you know from that analysis that there are parties who will be targeted. And under the Ninth Circuit case law, you can make a fairly good observation about where that will go. Those folks who are within that class of potential targets are not identified. And so we have comments today about not knowing whether a particular party is involved or should be involved or will be involved in litigation too down the road. I think that's one of the concerns in this case. It doesn't mean, I think that's just part of the notice that is a sort of constitutional due process notice on whether or not I'm a target. I think that's one of the issues the court will have to wrestle with, and that's why our objection was before the scheduling rather than on the date put into the motion filed Monday. The other part is I understand the court's bringing it up under the contested matter, and I think if the court takes the steps that it's described, it will essentially provide most of the adversary proceeding type of process by essentially turning this into a full contested matter and not a partial contested matter. And so I appreciate that approach, and that may alleviate many of the concerns that we have expressed. The other comment that I would like to make is Mr. Kornfeld described the Bonham case as being within a contested matter, except the context was after 600 adversary proceedings were filed. So the impact of what was going on in the contested matter was clear, and the targets of the adversary proceedings were clear. So that's a different structure in the Bonham case, and that's one of the concerns is that the adversary proceedings in Bonham, they had a lead adversary proceeding case in which many things were communicated. But that's why our position relates to the adversary proceeding structure, because this essentially is a foundational piece to collecting money, and that's sub one of the adversary proceeding rule. But I think if the court follows what the court has described here, I think that probably alleviates the procedural due process pieces, because the parties who are coming forward will, at least for their clients, be involved. But I think that there's still the issue on whether or not the class of people, whether it's investors or other parties, whether that class is adequately described, I think is still an issue for the court to review. Other than that, Your Honor, I don't have anything further for today's status conference and scheduling motion.
Thank you, Mr. Dyer. Just on the class issue, and this kind of dovetails with how I've been thinking about litigation 1 and litigation 2. Let's say there's some investor who received notice of what's going on and chooses not to participate or do anything, or doesn't understand the notice. We proceed forward. We have a contested hearing. There are parties that are contesting, and let's assume there's a contested evidentiary hearing, and I also make Ponzi findings, and I enter an order doing that. And then down the road, an investor gets sued and argues, well, makes the argument you're articulating that, well, it wasn't clear this was aimed at me, and I didn't know I was supposed to do anything, so I shouldn't be bound. I mean, isn't that an issue I'd make in the context of that investor when that party's actually sued? I mean, this is kind of thinking back to Chrysler, right? Chrysler wants to sell the business free and clear. It chooses who it gives notice to. There's an issue about the defective airbags, right? And those people make their arguments later when they're actually sued, and the approval of the sale may have consequences, but the court, when it's approving the sale, doesn't delineate those consequences for particular parties down the road. So I guess we need to, this gets to when do we talk about who's bound, right? And as I said, it seems to me the way this would ordinarily work in most litigation is we talk about that when someone's actually the defendant of litigation, and if that party wants to argue he, she, or it is not bound, or maybe this would be in the district court or state court or who knows where they're sued, but whichever court has that litigation would make the finding as to that particular party in that particular context. That's at least how I'm thinking about that. So how would you suggest I reconcile that with, well, we don't know exactly who may or may not be a target today? I mean, maybe we don't, and maybe that's a defect that's getting baked into the cake, and someone 2 years from now will say, well, that means there was a due process problem. But is that an issue I need to decide now?
Your Honor, I think that from my experience in the 2 or 3 Ponzi cases that I've been around, that it is going to be an issue that's going to be raised regardless of what your findings are, just as a practical affirmative defense pleading piece. But I think in what we're doing here, I think it's defining the class so that you actually, when you make your findings, and the Ponzi scheme findings are made, that essentially sets the foundation for the going forward pieces. And letting people know that they are within the class of targets, even if the litigating trustee, coming out of, I presume will come out of the plan in that fashion, even if the litigating trustee has all of the judgment on who they're going to pursue and why, whether it's a foreign country, whether it's they can't get anything out of the particular target, that's all typical litigation strategy. Here, I think the goal that is sought is, I don't disagree with the goal that is being sought there. It is, how do we make that a viable finding that doesn't get significantly attacked down the road when we know who the investors are, when the Ponzi scheme analysis knows where the money went. And that's the basis for the Ponzi scheme findings, that those parties are cued in early on as opposed to later on. The extreme case of somebody who isn't listed, doesn't know, didn't get a piece of paper that said anything was happening in the bankruptcy court. That's a fairly easy one for the court any court to look at and say, okay, you didn't know. They have no documents that show that. This is about, I think, the ones that we do know and the ones that the analysis would indicate that they are net positive under the Ninth Circuit kind of standards. That's the class of people who are the obvious targets that have to be considered. That can't be an unknown factor. There may be some grays on whether somebody qualifies if everything is not tick and tie, but that's the parties who are going to be the ones that you want bound by this kind of a finding because they're the ones you have the evidence for presently as it relates to the Ponzi scheme investigation. So that's why I think that there's a concern here, and you can reserve those matters to a second piece and observe that that's going to be part of it. May happen in litigation too, but I think we deal with what we do know now, and we want that plugged into the due process concerns that we would be addressing now. Does that make sense, Your Honor? Am I being clear on why I think this is a problem?
I understand what you're saying, Mr. Dyer. I'm not exactly sure how to cut through it, but I think the debtors in the committee should be thinking about these issues as well. And I'm not sure I'm going to be deciding now what someone wants to do later on, works later on. But there may be things that can or should be done now to strengthen arguments later on that people should be thinking about. So I think we're all kind of saying the same thing. And again, my thoughts on this are evolving, and I very much look forward to seeing what folks have to say in their objections. So thank you, Mr. Dyer. So Mr. Gurley, I'm not inclined to move any of the dates that have been set and that have been noticed out, including in the broader notice that was sent in response to Mr. Dyer's concerns. And I don't want to say today exactly what's going to unfold until I have a better sense of the playing field. So what I think makes sense would be to set a telephonic status conference, a further status conference for the 20th or the 21st when that deadline is passed. Whoever is going to file anything, those folks have filed things, they'll have framed up some issues. You'll have had a chance to review and think about them. I'll have had a chance to review and think about them. And maybe, I suspect, as we've heard today, we're going to be getting some scheduling objections, and some parties are going to say we need to do some discovery, and, one day for this trial isn't going to work, and next week's on the 27th is way, way too soon. I think there's going to be some traction to those arguments. I mean, I think if we're going to do this, I understand why it should be done once, and it should be done kind of right. One comment I'll just make for the guidance of everyone on the phone. I mean, when I have contested evidentiary hearings, my usual practice is I almost always invite and want post-trial briefings so that parties can make their legal arguments based upon the record that's actually developed at trial. So everyone should be aware that if you're substantively disputing the Ponzi issue and we're having a trial, you will have a chance to develop legal arguments based on the record that's actually made by the parties at that hearing. That's most useful to me, and I think particularly in this context, it's an opportunity everyone should have. So that 100% will be part of what we're doing. But I think having a hearing Wednesday, Thursday next week, and just getting a sense of where we're going process-wise would be helpful. And I'd like Mr. Will, if he could, a little bit of herding cats, but just get a sense of who's objecting, what are the issues. I think there's going to be some scheduling process issues. I mean, I do, as I've said, think I take what Chief Justice Roberts wrote to heart. I think it applies in Chapter 11. I wrote that in my Easter Day opinion. On the other hand, certainly, we don't want to bake some kind of procedural defect into this process from the beginning. I don't think that serves anyone well. And if, there's an appeal and we have a do-over, the estate's worse off, all the parties are worse off, and quite frankly, the court's worse off. So I don't want to embed the process with something that later on creates a do-over for potential. And again, I may very well conclude there was no Ponzi scheme. I mean, I don't want to suggest I'm predetermining the outcome in any way at all. But I'd like, once we have a sense of what the objections are, perhaps it's possible to herd the cats and have a preliminary discussion about process before getting on the phone with me. I think that would make that further status conference as productive as we can make it.
Your Honor, thank you. For the record, Julian Gurley. Your Honor, just a couple of things, and I appreciate the comments. Firstly, Your Honor, as I mentioned a few minutes ago, this financing is absolutely critical to the orderly administration of these estates, and it's needed, Your Honor, as I know Your Honor can sympathize, to make sure that estates have visibility and commitment for liquidity, which is, I think, at the end of the day, in the interest of all parties and all investors. That is why we have this financing. That's why the gift financing motion was filed on February 23rd. We gave, as I mentioned, adequate notice on regular notice for the hearing on the 27th. And again, absolutely agree with your comments. And as far as go in this direction, Mr. Dyer, but our intention is absolutely to do this once and do it right. And so the matrix is sort of doubling on notice in this case about the gift financing, potential implications, and the rest. Your Honor, I think today has been helpful from the perspective of fleshing out a little bit of what the opposition is going to look like. Just is helpful. Your Honor, I know in this court and elsewhere, especially bankruptcy lawyers on the phone are used to the tempo of contested, even evidentiary bankruptcy practice. This absolutely cannot hang up there. The 27th is the notice date, and we really do need that under our financing. Your Honor, I'm absolutely happy to herd the cats. What I suggest is, it sounds like, and we'll go back and listen to the recording, we do have identified parties. Obviously, Mr. Lesnick and I know each other really well. But for others, Your Honor, I would prefer, and if it pleases the court, to sort of nudge people this way. It sounds like we know who's objecting or who's on the line. If we could get on the phone with him today, if they think that they need discovery or depositions, I think they could tell me that today. I think we could start narrowing a lot of those issues well in advance this week of the actual objection deadline on the 18th, and hopefully meet and confer in a way that allows us to get a sense of what they believe they need or are entitled to, and give us a shot at holding around the 27th. And our hope, Your Honor, obviously would be to show up after the 18th in front of Your Honor for a status conference on the 20th or the 21st. I encourage it to be the 20th with sort of what we resolve with the Wolfen and what the 27th would hopefully look like. I just see no reason for us to wait another week before we start engaging with these parties. We've all been in bankruptcy cases or adversary proceedings where we're in trial, just a matter of weeks or before the filing. So with that, Your Honor, any other questions, or perhaps Mr. Kornfeld has anything to add to?
Thank you, Mr. Gurley, and just I'll just say that I agree with your point that nothing's stopping that discussion from starting. I need to borrow probably inaptly from former Defense Secretary Donald Rumsfeld. I mean, we kind of have the known knowns. There are probably some known unknowns and maybe even some unknown unknowns to come here. But certainly today's been helpful, I think, in evidencing that there are going to be quite a few parties opposing. Some of them, like Christensen's, very likely opposing substantively and not just process-wise. I mean, some of the other parties have concerns about, well, is this intended to affect us, and if so, how, which I understand they're being cautious. So I absolutely agree nothing prevents that discussion from starting whenever you'd like to do it. I think that's a good idea. But, Mr. Kornfeld, I interrupted you. I apologize.
Oh, of course not, Your Honor. I don't really have anything to add. I would support having a status conference next Wednesday, the 20th, if at all possible.
Okay. Why don't we'll continue today's omnibus hearing and status conference to next Wednesday, March 20th, 2 o'clock p.m. by phone, and get a better sense of where things are. I think with respect to the known knowns, I'd encourage that conversation to begin as soon as it can, and there may be some other parties, likely will be some other parties filing something next week that you'll need to rope into the process. But I'll get an update about kind of where we're at and next steps going forward. And we'll leave March 27th in person in Yakima on the calendar. So. Okay. I know it's been a long hearing, and I'm 45 minutes running late for my other Chapter 11 case, so I don't want to hold those people on the phone all it's now afternoon for too much longer. But if there's anything further anyone would like to cover today, Mr. Brewer.
No, thank you, Your
Honor. Mr. Kornfeld.
No, thanks for the time, Your Honor.
Anything, anyone else on the phone?
Your Honor, this is Matthew Lesnick. I'm sorry, I just didn't hear the time for the hearing on March 20th.
At 2 o'clock p.m.?
2 o'clock, thank you.
And my hope is that'll give the debtor some time